Thank you, Director Brothman. Good afternoon, everyone. My name is Anita Levels, one of the Civil Rights Outreach Coordinators here at the PHRC. And before we go any further, I'd like to introduce our Director of Education, Director Desiree Chang, to bring a welcome for this afternoon.
Thank you so much, OC Levels, and good afternoon to everyone, and thank you for joining us for today's Lunch and Learn, Understanding the Anti-DEI Landscape. As we know, the past few years have brought tremendous momentum around diversity, equity, and inclusion, and efforts that have proven to open doors, deepen conversations, and help organizations across our Commonwealth move closer to fairness and belonging for all. Despite this progress, more recently, we've witnessed, a growing backlash, an anti-DEI, if you will, movement that challenges the very principles of inclusion and equity that so many have worked so hard to advance. Today's session is an important opportunity to better understand this landscape, what's driving these challenges, how they're showing up in workplaces and communities, and most importantly, how we can continue to respond with clarity, courage, and purpose. As a reminder, here at the PHRC, our commitment remains steadfast. We continue to be deeply vested in social justice and equity work, even amid the complexities of the current climate. Our mission is to prevent discrimination and promote equal opportunity. And it's not just a legal responsibility, but a moral one. It is work that requires persistence, partnership, and a shared belief that every person deserves dignity and respect. And so as we listen and learn today, let's ground ourselves in that shared mission. Let's seek understanding not just of the challenges we face, but of the opportunities we have to reaffirm our values and strengthen our collective impact. And so I want to thank everyone again for being here and for the work that everyone is doing here at the PHRC and all of our partners within the community. And with that, I'll turn it back to, am I going back to OC Levels or should I?
Okay. Yep, that's perfect.
Thank
you so much. Thank you so much, Director Chang. Your words were just so poignant and a great foundation for our time today as we welcome the person of the hour. Our virtual PHRC Lunch and Learn featuring Professor Carla D. Pratt, the Ada Lois Sipuel Fisher Chair in Civil Rights, Race and Justice, College of Law, University of Oklahoma. Prior to joining the OU Law faculty, Professor Pratt as Dean at Washburn University School of Law, and prior to that, she served as Associate Dean for Academic Affairs, Associate Dean for Education, Equity, and the Nancy J. Lamont Faculty Scholar at Penn State University's Dixon School of Law. Welcome back to Pennsylvania today. We appreciate you being here, Professor Pratt. Professor Pratt also has served the legal profession and the greater community. From March 2012 to March 2018, she served as an Associate Justice for the Supreme Court of the Standing Rock Sioux Tribe in Fort Yates, North Dakota, hearing cases that presented a constitutional question under the United States Constitution and or the Standing Rock Sioux Constitution. She currently serves as a member of the Council to the ABA section of Legal Education and Admissions to the Bar. The Council is recognized by the U.S. Department of Education as the National Accrediting Agency for JD programs. Please, let's give a warm social justice lunch and learn welcome to Professor Carla D. Pratt.
Thank you so much, OC Levels. I really appreciate the warm welcome and the invitation to be with you today. I'm a Pennsylvania lawyer, and so it's always nice to speak to Pennsylvanians. So I do have to say I'm not speaking today on behalf of my employer or the state of Oklahoma or the ABA Council. I'm speaking exclusively in my personal capacity, and hopefully we can learn a little bit about the anti-DEI landscape today. So I want to start by taking us back into history, because understanding history often helps us understand where we are today and how we got to where we are today. And the new anti-DEI landscape that we're confronting today really is rooted in the history of competing visions of equality in America that existed at the founding. So when we moved from the Articles of Confederation to the Constitution, there were deeply competing visions of equality with respect to this new nation that was founded. And those tensions continue to be with us today. We see that in the Declaration of Independence, there's this bold declaration of equality that all men are created equal. Of course, we now interpret that to be inclusive gender-wise, but at the time, of course, women were not deemed to be part of the body politic, and equality was really something that was viewed as reserved for white men. The Articles of Confederation, which was our initial founding document, was really not concerned with individual or group equality. The form of equality that the Articles of Confederation were concerned with was rooted in ensuring that citizens traveling from one state to another would be treated equal by the state in which they were traveling to or traveling through, so that no one would be treated as a foreigner in these states that were coming together to form one nation. When we moved to the Constitution intentionally permitted inequality. And of course, that was necessary to move us from the Articles of Confederation to the Constitution, because we had a system of slavery that had been in place prior to the Constitution, and the states with economies that depended heavily on slavery would not have agreed to move from the Articles to the US Constitution if there was not some protection for their slave economy in those states. And so we see the Constitution creating some protections for the institution of slavery and permitting several forms of inequality. So, of course, people were presumed to not all have the same rights in the Constitution. People who were of African ancestry were presumed to have been capable of being reduced to slavery and enslaved. Women were not viewed as citizens who were enjoying all of the rights of citizens today. Citizens were really viewed as people with, citizens who had voting rights, I should say, and citizens who had the full rights of citizens. That was really viewed to be reserved to free white men. And so women and non-property owners could be excluded by states under the original Constitution. And then, of course, the original Constitution viewed Native Americans as outside the body politic of the United States because they were subject to the jurisdiction of their tribes. And so they were not viewed as full citizens of the United States. And it wasn't until Congress later passes a statute that grants full citizenship to Native Americans that changes. So these competing visions of equality are with us at the founding, and they continue to be with us throughout our history. They never leave us. And the two competing visions of equality are referred to by legal scholars as formal equality and substantive equality. So formal equality in the layman's parlance is often referred to as color blindness. And color blindness and formal equality really emphasize equal treatment under the law for every individual, regardless of their race or their positionality in the society. So this, of course, assumes that once discriminatory laws like slavery and Jim Crow laws are removed, that everyone is competing on a level playing field and everyone should be treated the same. Many Americans have embraced this view. They see race-conscious policies as unfair, as presenting some advantages to some people and not to others. And because they perceive it that way, it's viewed as a form of reverse discrimination. So substantive equality, which we typically refer to as racial justice, recognizes that there were centuries of racial oppression in the form of slavery, Jim Crow, Native American genocide, Native American removal, Native American allotment, Native American cultural assimilation projects that were aimed at cultural genocide. All of those projects impacted those racial groups differently, those minoritized racial groups differently, and created a different positionality with respect to each of those groups in our society. And substantive equality seeks to take account of that different positionality and argues that true equality requires proactive measures to undo the racial subordination that these groups have experienced as a result of historical oppression. So substantive equality argues for things like affirmative action and reparations, targeted investments in minoritized communities that were shut out of investments in the past, such as being shut out of certain neighborhoods where houses increase in value at a rapid rate due to redlining policies. Some people of color were not allowed to invest in those communities, right? So a targeted investment might be identifying those redlining communities and offering government subsidized interest rates to those communities for investment in those communities for people to purchase in those formerly redlined communities where banks were not affording as much lending opportunity to people as they were in non-redline communities. So substantive equality seeks to take account of all of that history and the racial inequality that was manufactured by that history. Substantive equality says that, you know, basically every race of human beings is equal, and therefore no single race should be suffering disproportionate social harm than other racial groups. And the only reason they are is because there were affirmative legal efforts to subordinate, marginalize, and oppress those groups that need, and that those actions in the past need to be remedied in the present day in some way. So the U.S. Supreme Court has historically adopted the formal equality view of equality. And this dates back to immediately after the Civil War. We see the U.S. Supreme Court confronting the interpretation of the Reconstruction Amendments, the 13th, 14th, and 15th Amendments to the Constitution, which are added during the Reconstruction era when the Southern states were not officially back in the Union yet, right? And so the Northern states had the power to add these amendments to the Constitution. The 14th Amendment is added, which includes an equal protection clause. So it prohibits states from depriving any person of life, liberty, or property without due process of law. And it prohibits states from denying to any person within the U.S. the equal protection of the laws. And so the court in the slaughterhouse cases, which dealt with actually not people of color who were plaintiffs, but primarily white butchers who were bringing a claim in New Orleans, claiming that a monopoly granted to a company owned by 17 men that required the butchers to slaughter their animals at the slaughterhouse that had been chosen by the Louisiana legislature for this monopoly on slaughtering, the butchers argued that that violated their individual rights in several ways. They argued that it violated the 13th Amendment because it was a form of involuntary servitude, that they were being forced to do work for the 17 men who owned the slaughterhouse. They were going to have to slaughter their animals there and pay a fee to the owners of that slaughterhouse when they really would prefer to slaughter the animal at their own butcher shop and not have to pay anyone a fee. And so they argued that that violated the 13th Amendment's ban on involuntary servitude. They argued that the 14th Amendment Equal Protection Clause was violated because they were not afforded equal protection of the law, because the monopoly was given to the 17 men who had the power and the relationships with the legislators to get the monopoly. And so they were being treated more favorably than the butchers, who were shut out of the ability to slaughter their animals on their own by this new law that required them to slaughter at the monopoly owned slaughterhouse. And they also made other claims under the 14th Amendment related to the Privileges and Immunities Clause, but I want to focus on the Equal Protection Clause claim because the U.S. Supreme Court emphasized that the 14th Amendment was aimed at protecting individual rights, not collective rights, not group rights. And so the court, as early as 1873 is narrowly interpreting the 14th Amendment so that it does not hold the possibility of protecting group rights. It does not hold the potential to protect one racial group from subordination by another racial group. So the anti-subordination view of the 14th Amendment that some held at this time in our history, when the Reconstruction Amendments are added to the Constitution, that hope is dashed by the U.S. Supreme Court, which adopts a formal equality view to say that the 14th Amendment Equal Protection Clause only protects individual rights, not group rights. The court, sometime later in Plessy versus Ferguson, an infamous decision that we probably have all heard of, reinforced the view of the individual rights protection view, I will call it. In Plessy versus Ferguson, the court was, of course, confronted with the issue of whether segregation in public accommodations was constitutional under the Equal Protection Clause of the 14th Amendment. And the court framed its decision around the idea that the law applied equally to all individuals, right? So white people were burdened by this law as individuals, just like Black people were burdened by the law in that they could not violate the segregation prohibition under the law. So a white person who wanted to sit next to Black people in a public accommodation was prohibited from doing that by the law. And so the court focuses on this formal individual equality view of the Equal Protection Clause rather than focusing on group-based protections, and basically, again, reinforces the decision in Slaughterhouse that the Equal Protection Clause of the 14th Amendment only protects individual rights. It provides no group rights protection. Fast forward to the modern day, in Chouette versus Coalition to Defend Affirmative Action, the U.S. Supreme Court upheld Michigan's constitutional amendment banning race-conscious affirmative action in public university admissions. The court emphasized again that the 14th Amendment protects individuals from racial discrimination, that it does not protect racial groups from racial subordination to any other group. And so affirmative action became a testing ground, if you will, for testing the validity of the notion of group rights. And then, of course, we get in 2023, the most recent affirmative action case, Students for Fair Admission versus Harvard, where the court again stresses that the 14th Amendment guarantees equal protection to individuals, that it does not guarantee equality to groups. And so we'll come back to Students for Fair Admission a little bit later, because I do want to dive into the case a little bit more. So these competing visions of equality basically have led us to where we are today, where we have criticisms of critical race theory and a rejection of the diversity, equity, and inclusion framework that had been in place in terms of trying to seek equality. So I want to first start with talking about critical race theory because there's not a clear understanding of what it is. Critical race theory is a genre of legal studies. It originated in law schools, and the image there on the screen is a book that assembles the key writings that formed the critical race theory movement in legal education. And these were law professors, legal scholars, writing about their view of equality, which really was grounded in historical context and was grounded in their view that the 14th Amendment was intended to have a broader interpretation than the formal equality view. So the founding father of critical race theory was Professor Derek Bell at Harvard University School of Law. He defined critical race theory as telling the truth even in the face of criticism. And so critical race theory was really criticized at its birth. There were hostile articles back and forth between critical race theorists and anti-race crits who criticized the critical race theorists for the work that they were doing in legal education. They called it anti-intellectual. They called it as a devalued form of scholarship. They said it wasn't true legal scholarship. And so there was a lot of hostility to critical race theory at its birth. Derek Bell said, education leads to enlightenment, and enlightenment opens the way to empathy, and empathy foreshadows reform. And so what he was saying there was that we need to educate law students about the various views of equality so that students understand that there's not merely one view of equality. And so once we educate students, they're enlightened, and that enlightenment can lead the way to empathy, where students start to understand the struggles of various groups. And this includes groups of white people. So one of the things that critical race theory did was to highlight how race and the rules of racial discrimination that had been in place throughout our history actually harmed poor white people as well. Because one of the most infamous cases that's used to illustrate this is the case of Buck versus Bell, where Carrie Buck is a young white woman, and she is in foster care, and she becomes pregnant, and her foster family, sends her off to the state saying she's morally debased, she's an immoral person because she's engaged in out of wedlock sex, and she's creating this imbecile of a baby. And so she gets institutionalized in Virginia, and Virginia has a sterilization law that requires the sterilization of people who are deemed to be feeble-minded or imbeciles. And of course, this was part of the eugenics movement, but it all fed into this theory of whiteness, right? If you were not performing your whiteness in accordance with the positive stereotypes associated with whiteness, there must be something wrong with you. You must be feeble-minded or an imbecile, and we need to sterilize you so you don't produce more feeble-minded white people. And so Carrie Buck was sterilized against her will. And the case is notorious because years later, psychologists interviewed and administered IQ testing to Carrie Buck and determined that she was a woman of average intelligence. And of course, it came out that she was raped in her foster home, and she became pregnant because of that sexual abuse. And so there was no immorality, but the dominant narrative that was told about Carrie originated in this notion of whiteness being pure and moral and intellectual, and all of these tropes Carrie Buck did not represent, and so she had to be sterilized as a result. So some of the core tenets of critical race theory are rooted in group rights, right? They're rooted in viewing the 14th Amendment through the lens, not of formal equality, right, but of what we call substantive equality, that we're looking for equality as a matter of result. So one of the tenets is no racial group is inferior to another in capacity, ability, morality, or intellect. And so in every racial group, we have people who are part of the intellectual elite. They're the Mensa group, right? We have people who are average intelligence, and we have people who have intellectual disabilities in every racial group, right? In every racial group, we have people who follow the laws and never break a law, live their entire lives as citizens who never break a criminal law in the society. And then we have people who break the law. And so that's across every racial group, right? And so this notion that certain racial groups are less intelligent, less moral, less capable, less worthy, critical race theory rejects that, right? And because critical race theory says that every racial group of human beings is equal in capacity, ability, morality, intellect, and the like, the corollary to that necessarily is that no racial group is inferior to another, and therefore all racial groups should experience roughly equal social outcomes. So racial groups should enjoy roughly equal positive social outcomes, right? Roughly equal levels of education, roughly equal levels of wealth, roughly equal levels of income, and no racial group should suffer substantially more negative social outcomes, right? No racial group should have higher levels of incarceration, higher levels of drug addiction, higher levels of early premature death, and the like. So critical race theory posits that when some racial groups enjoy substantially more positive social outcomes and other racial groups suffer substantially more negative social outcomes, that law should intervene to remedy that injustice and achieve social justice. And this is the group rights or the group equality view of the 14th Amendment's equal protection mandate. So critical race theory came under attack primarily from this young man named Christopher Rufo, who's a conservative. He said, "I've led the fight against critical race theory in American institutions. We've successfully frozen their brand, and we are driving up negative perceptions. We will eventually turn it toxic as we put all of the various cultural insanities under that broad category." And so Christopher Rufo rejects the group-based view, the substantive rights view of the 14th Amendment, and embraces the view of formal equality, right? That no individual should be treated differently from any other, regardless of what the outcomes are produced by that. Formal equality mandates it. This is Mr. Rufo's beautiful family. And so, it's important to understand that this perspective that he has is what's driving the case in Students for Fair Admissions, because we're going to talk about in a moment how Asian American students were, by the raw numbers, the most qualified applicants to Harvard University, but they were experiencing the lowest admission rate of any racial group. And so you can imagine that Mr. Rufo would think, my Asian children are going to not have an equal chance to compete if race conscious affirmative action disfavors their racial identity. Criticisms of critical race theory, some of them are not grounded in sound 14th Amendment jurisprudence. And one example of that is this notion that critical race theory is Black supremacist racism. I have been unable to find any critical race theory author that has argued that Black Americans should be superior to any other race or are superior to any other race. That no critical race theory author that I've read or come across has argued as a normative principle that Black people should be superior to any other race. So there's no notion of Black supremacy in critical race theory. The other trope that is out there is critical race theory is the terrible apotheosis of wokeness. And so, it kind of concerns me that we are vilifying perspective, right? That wokeness is viewed as people who are somehow a threat to equality, right? When we had education around the experience of people of color in our public schools and in our higher education frameworks, we were able for all students to understand the lived experiences of various racial groups. And as Derek Bell said, once you understand the lived experience of another racial group, you can have empathy for that racial group, and you can have a desire to perhaps to have law remedy some of the social harms that that racial group is still suffering today. And so that's kind of what I think Rufo and his colleagues are calling wokeness, right? Is that enlightenment that Derek Bell is talking about. And that's why there's been like this pushback against empathy, right? We know from social science research that empathy is a human trait that we want to cultivate in each other, because the lack of empathy leads to what we saw during World War II, right? The genocide of an entire group of people on the basis of their ethnicity, right? And so cultivating empathy among human beings in society is really important for protecting against that kind of dehumanization. False history. So critical race theory is also criticized for creating a false narrative with respect to history. Really what critical race theory does is it tells the story of history from the perspective of people who were conquered, Native Americans, from the perspective of people who were enslaved, African Americans, right? And so it is pushing back against the dominant narrative of those who were the conquerors and the enslavers. And so in that way, that dominant narrative is threatened, right? And so, one example of this false history critique that I like to point out is today we collectively refer to the Civil War as the Civil War in the US, right? But immediately after, if you read the historical documents that refer to the war, immediately following the war, it was referred to as the War of the Rebellion. it was referred to as a treasonous act, right? But it's the effort of those who have power in the society in the southern states to reformulate what happened in the Civil War in a positive sense, that they were patriots fighting for a good cause, right? The lost cause. And so the whole society moves away from calling it the War of the Rebellion to now simply calling it the Civil War, right? And so, you know, I have this quote from Will Rogers because he's an Oklahoman and I'm a native Oklahoman speaking to you from Oklahoma. And he said, don't be misled by history or any other unreliable source. And what he's saying there, of course, is that history is always contested. History is the story told by those who have the power to engage in storytelling and control the narrative. And so critical race theory pushes back against that and says there are stories of experiences that aren't being told, that need to be told, and that we need a fuller understanding of history. You probably know that there are many states now that have anti-critical race theory laws, and my state, my home state, Oklahoma, is one of them. The Oklahoma law prohibits the teaching of critical race theory in public schools K through 12 is what they're focusing on in this legislation, which was interesting because I thought, wow, you know, we are really doing something if we're teaching critical race theory to kids in K through 12, because most students aren't studying critical race theory until they get to law school. But as Christopher Rufo said, you know, we're going to put everything under this brand and tarnish it, right? And so that's what's happening here. The proponents of this law are moving things that are diversity, equity, and inclusion related under this anti-CRT umbrella. And so the law prohibits an individual, states that an individual should not be teaching the following principles if they're teaching in Oklahoma public schools. They shouldn't be teaching the principle that an individual should be discriminated against or receive adverse treatment solely or partly because of his or her race. Well, I don't think we want anyone teaching that, but what they're really getting at there is that no teacher should be teaching the principle of affirmative action, right? That teaching that some groups should be afforded some opportunities that other groups should not be afforded is teaching a form of discrimination on the basis of their sex or race. The next principle, members of one race or sex should not attempt to treat others without respect to race or sex, meaning that this bans the teaching of the benefits of race consciousness, right? And it bans the teachings about the harms of colorblindness, right? So, you know, when we first read it, though, it seems like, of course, that would, yeah, we don't want that. We don't want them teaching that an individual should feel discomfort, guilt, anguish, or any form of psychological distress on account of race or sex. Well, of course, you know, most people would agree with that, right? But that bans the teaching of the presence of white racial dominance and male dominance in our society, right? And so it prevents teachers from using data that is actual data to show that whites in our society enjoy social dominance in wealth, in income, in education and the like, right? So this whole anti-DEI framework has been put under the anti-CRT legislation, and with principles that most people would agree with, that we shouldn't be teaching these things as they're phrased in the legislation, but there's a subtext to the legislation that is really what's being regulated. So core tenets of critical race theory, I mentioned a few before. Other core tenets are that racism has not been eliminated. So you probably remember back in the Obama era where people were walking around saying, oh, we've got a Black president now. We're post-racial. We're beyond racism. Racism has been eliminated in the US. Isn't this a great thing? And, there were other people saying, no, racism is still alive and well. And the dominant voice was screaming, "No, we are a post-racial society." Critical race theory says, no, racism hasn't been eliminated. It's just changed form. It just looks different and operates differently today than it did in the past. Another core tenet is law should be mobilized to fight racial injustice, including racial inequality. And so a core tenet of critical race theory is that because law helped create the racial inequality that we see in our society, law has a moral obligation as a tool of justice to disrupt the racial inequality that it helped to create. A third tenet of critical race theory is that law should ensure equal democratic participation for all members of society. And so this is why a lot of critical race theorists are opposed to things like voter ID laws, because those laws operate to limit democratic participation, and they disproportionately impact the more vulnerable people in the society, who oftentimes are racial minorities. A fourth tenet, racial inequality. We also refer to this as white racial dominance, right? That racial inequality does not exist because white people are smarter, better, hardworking, morally superior, or more intelligent. It exists because it was manufactured by the society through 400 years of slavery institutionalized by law and 100 years of Jim Crow segregation and oppression institutionalized by law, and generations of cultural genocide toward Native Americans institutionalized by law that produced the racial inequality that we see today. Critical race theory believes that we should explore different perspectives, that everybody's voice matters and that everybody's voice should be included, and that our legal system has and sometimes continues to facilitate and perpetuate racial inequality. And so this is what we call, the reference to systemic racism. And so people, a lot of people, again, believe this does not exist, right? And so critical race theory scholars write about it to demonstrate and illustrate how racism operates systemically in our society. 7, law's antagonism toward racial equality and racial equity in American society perpetuates racial dominance. And what this tenet says is that the adoption of the formal equality paradigm and the rejection of the substantive equality paradigm actually allows racial inequality to continue and replicate itself in our society. So an area where the two views of American equality clash is, of course, race-conscious affirmative action. And race-conscious affirmative action was disliked by some Americans because it did not treat every individual the same. Remember, I said Christopher Rufo is probably opposed to race-conscious affirmative action because his Asian children were not going to be given any kind of fair treatment in his mind when it came time for them to apply to college. They were going to be competing for admission to the best colleges, and there were going to be some students who were going to get a bump up or some favoritism in their consideration because of their favored racial group. They were a member of the Latinx group, or they were a member the African American or Black group. And so because the African American or Black group and the Latinx or Hispanic groups were not represented at their proportional levels in higher education, race-conscious affirmative action focused on those groups because those were the groups that were suffering the negative social harm of being excluded from higher education institutions. Race-conscious affirmative action did not focus on helping Asian Americans or white Americans because those racial groups did not suffer disparate exclusion from institutions of higher education. So the criticism of that, of course, is that, yeah, that's fine if you're looking at things on the group level, but if you're looking at things on the individual level, it's not fair. It's not fair for the poor white kid who grew up, extremely poor in rural Oklahoma to have to compete with the African American child who, grew up affluent and had private school education, and they're both applying to Harvard University. Why should the African American child get some boost by getting to the consideration of their race to be considered in their application, and the white child gets no boost in their application because of their race? Again, it all depends on whether you're looking at it at that individual level or whether you're looking at it at the group level, right? So if you're looking at it at the individual level, the individual white student, of course, is not being treated equally with the individual African American applicant who's applying at the same time. That's the concern of formal equality. Race-conscious affirmative action rejected colorblindness. Colorblindness is another principle that formal equality adheres to. Race-conscious affirmative action rejected colorblindness because it considered race. It was conscious of race in hiring and higher education admissions. Race-conscious colorblindness, race-conscious affirmative action, I should say, rejected colorblindness as a theory. And race-conscious affirmative action rejected colorblindness because race-conscious affirmative action was deemed to be a response to the reality that race is a social construct that still holds meaning for individuals in our society to this day. For example, Black people are presumed to be less competent, we're presumed to be less intelligent than our white counterparts. And as a result of that, we labor under those stereotypes when we apply for a job. We labor under those stereotypes when we apply for a promotion. We labor under those stereotypes when we apply for admission to a higher education institution. And so race-conscious affirmative action sought to offset those presumptions and stereotypes that were affixed to one's race by allowing institutions to consider race as a plus factor rather than having race operate as a subconscious negative that pulls a candidate's application down, right? So again, all about perspective. So affirmative action is necessarily then derived from the critical race theory or the substantive equality perspective. It's grounded in the idea that a government that has used its power to oppress and subjugate a group of people owes that a duty to those people, not only to stop oppressing them, but to also take positive steps toward remedying the harmful results of that oppression. Excuse me, we see the birth of affirmative action right after the Civil War during the Reconstruction era. And we see it in Congress passing a statute creating the Freedmen's Bureau. In 1865, the Freedmen's Bureau is created to support the formerly enslaved people and help them transition from slavery to freedom. You can imagine people who were enslaved one day and free the next, right? They have nothing but the clothes on their back. They don't have a job that will provide them with wages so that they can go buy food. They don't have access to health care. They don't have access to housing because the former slave master provided the housing, and he's saying, if you're not going to be my slave, you can't live in my housing, right? So the Freedmen's Bureau was there to ensure that the recently freed people had basic human necessities as they transitioned to freedom, and it helped them basically negotiate contracts with their with former slaveholders or other business owners in the society who needed labor. It helped them negotiate a fair contract so that they could be paid fairly for their labor. So the Freedmen's Bureau, though, was not popular, right? There was extreme resistance to the Freedmen's Bureau because it was a form of affirmative action by government aimed at helping one particular group of people. And so the criticism was that the Bureau gave a preference to one group of citizens over other citizens. This is the same argument that we see in the modern day affirmative action context, right? That government is giving a preference to one group of citizens over other citizens, completely ignoring the fact that that preference for the formerly enslaved people is given because law had allowed them to be enslaved and subjugated for 400 years that resulted in their inability to have the agency to get employment and provide for their basic necessities. So Congress ends up dismantling the Freedmen's Bureau a short time after it's created in 1872 due to the political opposition. Opponents argued that the Freedmen's Bureau also interfered with states' rights, right? That the Southern states did not want to have the federal government providing any kind of preference to some of their state citizens over others. This is a political ad that was used to basically foment the racial resentment of hardworking Southern white planters at the time to basically say, hey, look, you guys are working hard. You see the white farmer there, he's got to chop something with that axe. He's working really hard. And then the African American formerly enslaved people are represented in the ape-like human being there, laying back with his feet kicked up, relaxing. And the narrative at the time was that the Freedmen's Bureau is just providing welfare to Black people, giving them all that they need so that they can just lay up and live a life of leisure, while white people have to work really, really hard and pay taxes to sustain the government and to allow the government to pay Black people this social welfare benefits. And so you can imagine poor, hardworking white people were really incensed at the idea that their tax dollars were being used to afford the formerly enslaved African Americans a life of leisure, right? Of course, that's a political spin on the reality that was happening in order to get white people to vote for the candidate who was going to put an end to the Freedmen's Bureau. After Reconstruction, affirmative action dies, right? This view of the 14th Amendment as a vehicle that could actually operate to remedy group racial injustice dies along with it, right? And so the formal equality view takes hold. it enables 99 years, nearly a century of post-slavery racialized oppression in the form of Jim Crow. And critical race theory really focuses on the group-based subordination that is created by slavery and Jim Crow that ensures that most Black people are going to be subordinate to most white people in the US in education, in employment, in income, in wealth, and in political power. Those laws operated as, Justice Ginsburg would say, the boots on the back of your neck, right? Keeping these groups of people down and subordinate to whites. Jim Crow ends with a landmark Supreme Court decision in Brown versus Board of Education. It was a unanimous decision that Justice Earl Warren was able to negotiate with his other conservative jurists on the court to end de jure racial segregation in public education. It was not a favorable decision. Dwight Eisenhower, who had been pro-segregationist, had to send in the National Guard to Little Rock, Arkansas, so that the 9 African-American students there could walk into the formerly all-white school and integrate that school. Even though Dwight Eisenhower had been a pro-segregation president, once the court renders this decision, even though he does not like it, he respects the rule of law and he sends the National Guard to Little Rock, Arkansas to enforce the rule of law. But Brown versus Board of Education is quickly narrowed. So the potential of Brown to be interpreted broadly to say that all children in America are entitled to equality in education, that is quickly put to bed. No, we're not interpreting Brown that broadly. We're going to interpret Brown narrowly to merely say that you cannot have de jure racial segregation. It can't be mandated by law. Oh my gosh, we're almost running out of time.
This is so great. I just wanted to let everyone know if they did have to leave at 1 o'clock that we're aware of that. But yes. Professor Pratt does plan to take questions at the end of the presentation today.
Mm-hmm. So when do we have a hard stop?
Our lunch and learns are from 12 to 1 p.m.
Okay. So we've really got a hard stop now.
Yes, but I'm sorry for the miscommunication of that, but would you mind wrapping up maybe within the next 10 minutes or however you're flowing? So
Anita, do you mind if I jump in just to make a suggestion? I would say at this point we can invite people that have to leave, but if people are welcome to stay, they can continue to stay and we can continue this meeting. And for those that do have to leave, it will be available on our YouTube page for you to continue hearing Professor Pratt's presentation.
Thank you for that. So I'll quickly wrap up. So in the modern era, we get Lyndon B. Johnson, who, probably didn't consider himself a critical race theorist, but he beautifully stated one of the understandings of critical race theory. He said, that you don't take a person who for years has been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say, you are free to compete with all of the others and still justly believe that you've been completely fair. We seek not just equality as a theory, but as a fact and equality as a result. And that really sums up the idea of critical race theory from President Lyndon Johnson. So again, we've kind of gone over this in terms of critical race theory's posture. It's really about anti-subordination, that no racial group should be subordinate to another in our society. And the irony about critical race theory is that, demographers are predicting that by the year 2044, people of color are going to be the majority in the US. And if it ever happened that people of color began as the majority to form a coalition to oppress white Americans, critical race theory would be the tool that I would use to argue that law should not tolerate the subordination of white Americans to other racial groups, right? So critical race theory is about ensuring that no one racial group has to suffer negative social outcomes disproportionately to other groups. Again, this is just about differing views of equality, formal equality versus substantive equality. And so we see the Supreme Court ultimately in Students for Fair Admission adopting once and for all the formal equality view of the Equal Protection Clause and saying that even in the context of affirmative action in higher education, we are not going to allow the consideration of race in this context because the court said this is a high stakes admissions process where the admission of some students necessarily means the exclusion of other students. And so the court holds that race conscious admissions policies and practices violate the Equal Protection Clause of the 14th Amendment, and in this case of Harvard, because it's not a state actor, Title VI, which impacts all institutions that applies to all institutions that receive federal funding, and of course Harvard receives federal funding. So the court adopts this formal equality view, focusing on the individual's right to be treated equally, but the court acknowledges that schools could consider the individual student's unique ability to contribute to the university. So if schools want to consider a student's personal statement and how their life has affected the person that they are today, including their racialized experiences, the school can consider that student's unique ability to contribute to the university. So how do we navigate this anti-DEI landscape today? We have to think about adopting policies that afford every race equal opportunity. So how do we do that? Maybe we do that in a race neutral way that focuses on capturing people who are vulnerable in our society, like Carrie Buck, right? Poor white people should be a concern of law, and the social harms that they suffer should also be a concern of law. So maybe we formulate policies around socioeconomic status, and we bring more people at the bottom of our society into opportunity. We should make it clear that we are not doing anything that's racially exclusive, right? And I'll give an example of this. A lot of people come to law school and they think the Black Law Students Association is just for Black students. And so we have to make it clear, all student organizations are open to all students. The Black Law Students Association is committed to ensuring that they examine law from the lens of how law impacts the African diaspora of people. And so if you're interested in that issue, you can be a member of BALSA, right? And so making it clear that what we're doing is not about racial exclusion. We have to make sure that we avoid group-based frameworks, right? Because the group framework has been rejected by the court. I found this great website from Baker Hostetler on insights that I thought were useful that I posted there on the last slide, if you want to check that out on your own time. Thank you for having me today.
Thank you so much, Professor Pratt. Thank you. I so apologize that we felt rushed towards the end. Everything was just so great, so good. We do have a question. We will say if you do have any questions, so thank you so much for taking questions today. We appreciate that. If you have questions, you can put them in the chat, or you can raise your hand and we can take you off mute for your question. So, LZ, who do we have here? LZ? I can see your name.
Hi, my name is Lydia Zbudzinski. I'm an investigator with the PHRC. Thank you so much, Professor Pratt. That was an absolutely outstanding presentation. I have two questions to ask you. So I was so happy that you addressed the gross misunderstanding of critical race theory and the fact that, like other theories, you'd be hard pressed to find a K through 12 school in the US that teaches any of them. But then going into intersectionality, I'm a really big fan of Kimberly Crenshaw, who is also, of course, a CRT theorist and coined intersectionality. And she has written so much about the way that all of these different classes converge together, and it's not possible to view just one to understand socioeconomic standings. So addressing one of the examples that you brought up of the proverbial circumstance in which a poor white person is disadvantaged by affirmative action for a well-off person who is advantaged by affirmative action. Do you think that it would be possible to translate intersectional Marxian class theory and that application of CRT to the masses to address this misunderstanding and, in fact, misinformation that has come out about it?
That's a great question. You know, the beauty about America, right, is that we all have the ability to embrace the view of equality that we think is the right view and to advocate for that view. And so, yeah, I think there's space to do that. I think there's space to build coalitions, but, you know, we have to be mindful of the fact that there are systemic forces that are at play that seek to prevent the building of coalitions for this very purpose, right? Because if we are able to build a coalition around a substantive equality view of the Equal Protection Clause and get people to understand that, and then motivate those people to go to the polls and vote that view, then we could see a shift in how the 14th Amendment is interpreted. But there are a lot of forces that operate to create division, to prevent those coalitions from being created. And there are a lot of forces at play that operate to keep people in the dark, right? The fact that we are one of the wealthiest countries in the nation, but we don't afford higher education that's free higher education to our students who are who have been working academically to pursue higher education, want higher education. We don't have any kind of government funded program like a lot of other nations that invests in the higher education of our students. Government investment really stops at K through 12, right? So that lack of education for students really puts us at a disadvantage when it comes to talking about these very sophisticated, nuanced understandings of equality and justice. If you don't have a decent educational foundation, my presentation probably won't make a whole lot of sense to you, right?
Mm-hmm. Thank you so much, Professor Pratt. Such a great question. We have another question. I think I read the name Kate Messenger. Thank you, Kate. You're off mute. You want to go ahead with your question? You can. You may. Can't hear you if you're speaking. Okay, you're going to switch to text. All right. Kate is texting. If anyone else has any other questions, feel free to raise your hand or put that in the chat. Thank you again, Professor. This is so great.
Well, I want to thank you all for the work that you're doing. It's very important.
Okay, here is Kate Messenger. How can an individual equally be protected? It's the same individual as a member of a subordinate group. There is more context there. I hope I'm reading that correctly. How can an individual equally be protected as someone who's also part of a subordinate group? I'm assuming that's what you're asking, Kate? That makes sense. Yes, okay.
Okay, so how can an individual be protected if they are part of a subordinated group?
Yeah, how can an individual also be equally protected if they're also a part of the subordinate group? How can they be equally protected? I think that's the question she's asking.
Yeah, yeah. So again, I think the formal view of equality would say that that person is equally protected as long as there's not affirmative discrimination against them. So the positionality of the person is ignored in that framework. The fact that they're subordinate in terms of their income or their wealth or the education level of their parents or any of those social factors is ignored, because the focus is only on how they're being treated in that one instance
As an individual.
as an individual.
Mm-hmm. Thank you so much for clarifying the 14th Amendment and how that has had a pervasive impact on where we are today. I think that also kind of helps answer your question. I hope that helps, Kate. We have another question. One more question from the previous person with the question. Go ahead.
Hi, sorry, I just had one more question for you. So with the return to the formal view of equality, I'm wondering, because there's cases like Brown v. Board, Loving, Virginia, and Obergefell that all shifted the interpretation of the EPC towards a substantive perspective. And, you know, they shifted towards examining the purpose of the laws and the social meaning of the laws. And although we've seen these recent cases that have kind of returned to this formal view, do you see a future where substantive equality is legitimized at the federal level again, despite the current composition of SCOTUS?
I don't see that happening unless something radically disruptive were to happen at the Supreme Court level. So, you know, if we got a progressive president after President Trump who decided to pack the court with more progressive justices such that they could grab the power and pull the pendulum back to a substantive equality view of the 14th Amendment, that could happen. But that would be a radical action that, you know, even when FDR proposed his court packing plan to get his New Deal legislation endorsed by the court, he was opposed by many members of his own party. So, you know, I think any talk of packing the court will be viewed as a radical departure from the norm, but there's nothing in the Constitution that mandates the number of justices that are to sit on the court. And so, you know, what I see is that, you know, we've been testing our democracy a lot, and we identified a lot of gaps. And so I really think that we're at an inflection point where we have identified a lot of opportunities for undermining our democracy, and there's perhaps a need for a new constitutional convention to amend this document or create a new document that addresses some of the instabilities, some of the things that were not in the document, that as a society we have been having a tug of war over, right? And maybe we can't get there because we're still having the tug of war, and if we had a constitutional convention, we wouldn't achieve any outcome. But you know, the lack of a number of justices in the Constitution creates that vulnerability that we could get a president who would decide to pack the court in order to have his or her agenda advanced.
Thank you for that input. Thank you so much. Thank you so much. As far as speaking to the Supreme Court, we're in such, you're right, times that are changing so quickly, so frequently, and times that we haven't seen in a long time. It's interesting to see the news, and they'll pull out a legislation from 18 such. I'm like, whoa, wait a minute. So it's like learning new law almost every week right now. So, it's so good to have you here to speak more to what's going on in this anti-DEI landscape, and to even the phrase that you're saying, the competing visions of equality, and the dichotomy of that is, of course, it still seems what we're still dealing with today. So, any further questions from anyone here? I think we're so good. I think we'll take one more question. If not, we'll. Speaking of, Kimberly Crenshaw wrote for y'all review suggesting an amendment to the Constitution, permanently apply 14th Amendment and EPC to women and minorities are found compelling. Unfortunately, our current climate is unhospitable to even a discussion of it. Thank you so much for your thoughtful answers to our questions and a fantastic presentation. And I also echo that, and I'm pretty sure I'm not the only one. Professor Pratt, thank you so much for being with us today. Thank you for your time. Your information is so vital, in particular for this landscape. So thank you for being with us today. Appreciate it.
Thank you.
Yes, all the thank yous that are here in the chat. Thank you all again for being with us, even past the 1 o'clock. We were, Professor Pratt, we're like, oh my goodness. And I'm like, oh my goodness.
My students would have all left by now. So, I appreciate,
but hey, we are here. We're enjoying it.
Absolutely.
Absolutely. We do have another Lunch and Learn coming up on November 5th. We're going to be talking about understanding the wealth gap from Dr. Adia Robinson. So we hope that you'll join us then. Thank you all so much for joining us today. Again, thank you, Professor Pratt, for being with us today. You all have a great rest of your afternoon.